The Center for Continuing Education, CCE, is a State Bar of California MCLE approved provider. The Center for Continuing Education, CCE, presents Avoiding Liability in H-1B Cases. Today's program features two highly respected San Francisco-based immigration law attorneys. Robert G. Werner has been practicing immigration law in San Francisco since 1971. He received his A.B. from Harvard College cum laude in 1967 and his J.D. from the University of California at Berkeley in 1970, where he graduated in the top 10% of his class and was editor of the Law Review. Mr. Werner has been granted the highest Martindale-Hubbell AV preeminent rating for both legal ability and ethical standards. Mr. Werner has been certified as a legal specialist in immigration and nationality law by the State Bar of California Board of Legal Specialization for over 20 years. He was in the first group of immigration law specialists to be so certified. Mr. Werner serves on the California State Bar Immigration and Nationality Advisory Commission, helping to write and grade the immigration specialty exam. He has been designated a Northern California super lawyer in the field of immigration law by his peers. James A. Bach has been working exclusively with immigration cases for several decades and has lectured and written extensively on immigration law subjects. Mr. Bach is one of less than 8% of California immigration attorneys certified by the State Bar of California Board of Legal Specialization as a certified specialist in immigration and nationality law. He has been given the highest AV rating by Martindale-Hubbell for ability and ethics for over a decade, and is included in the current Martindale-Hubbell Bar Register of Preeminent Lawyers. From 1987 to 1990, Mr. Bach was the head of the Immigration Law Department of Crosby, Heafy, Roach, and May, now Reed Smith. Currently, Mr. Bach serves as the chair of the State Bar's Immigration and Nationality Advisory Commission, which writes and grades the California Immigration and Nationality Specialty Examination. He is also an arbitrator for the San Francisco Bar Association.
Hello, thank you for joining us today. Our topic is avoiding liability in H-1B cases. I'm with Robert Werner. I'm James Bach. We're both employment immigration lawyers in San Francisco. And when we talk about liability in H-1B cases, we're looking at not really the H-1B case itself, but the labor condition application. That's where the liability resides. So it's more Department of Labor liability than USCIS liability. And also we're going to talk about, of course, the employer's liability, but attorneys might have some liability as well, and we're going to address ways to avoid attorney liability as well. So to start our program, Robert Werner is going to talk about the LCA posting and file keeping requirements.
So I'll start off by asking why this is extremely important for the clients. And this was brought home dramatically a couple months ago when a public school district in Maryland agreed to pay $4.2 million in a settlement with the Department of Labor for back wages for their H-1B employees. They had no idea that they were failing to pay the required wage because they were making the individuals that they hired pay the filing fees and the attorney's fees. And under the Department of Labor's regulations, which are quite complex and not so simple to comply with, but extremely important, this lowered the wage of the employees below the actual wages. And that's how they arrived at this $4.2 million. That is how much they were underpaying their teachers during this time period. Now, in addition to that, they also agreed to pay $100,000 civil fines for the violations, and they also agreed, and this is perhaps the most significant for most of your clients, that they would not be able to file and have approved any petitions for any foreign workers, either under the H-1B provisions or under the green card provisions for a 2-year period. And for many businesses, that would be devastating. So this is something that's extremely important, very serious, and critical that you properly advise your clients about the requirements.
Right, and if I could interject there, it's also, Bob, something that's not immediately apparent from the regulations. What is apparent is that if the employee pays the $1,500 or the $750 training fee, that is explicitly proscribed in the regulations. But what was going on here is that the employee was paying these other costs that brought the prevailing, not actually brought the required wage or the wage they were actually paid down below the required wage.
Good point, Jim. The regs, in fact, can be somewhat misleading to someone who's not very experienced in this area. If you go looking to find out what filing fees is the individual allowed to pay or not, you would find the regulation says, well, the one that the employee cannot pay is this training fee, which is only one of the 3 fees that have to be filed. So a logical conclusion might be that the other 2 they could pay, but because of the other complex provisions of these regulations, in fact, in virtually all situations I can think of, it would bring the wage below the actual wage paid to other workers who don't have to pay these filing fees. And that's how they conclude that there's liability.
Right, and the concept there is that these are fees that the employer should normally be paying, so that if the employee picks them up, then it's coming out of the employee's pocket and reducing the employee's wage. So we have the training fee, which is clear. We have the basic filing fee. We have the fraud fee of $500. And then we have the legal fees. Now, legal fees are something that you would think any client could pay to any lawyer to represent them, and that would not be somehow illegal or cause a violation under the regulations. But just the act of paying the legal fees gets you under that required threshold amount, or if it does get you under that amount, then the employer is in violation. And the 4th type of fee is the premium processing fee of $1,225. Now, let's assume that you have an employee that needs to go back to India to take a trip. Their current visa has expired, and they need to have the case processed right away. The employer has no interest in premium processing. How do you handle that, Bob, for the premium processing? Do you consider that to be an employer's expense, or can the employee say that that's my personal expense?
Well, I can see that you could argue either way, but I'm sure the Department of Labor would take the position that that is something that reduces the net wage that you're paying, the employer is paying to the individual employee, and could certainly subject the employer to back wage liability as indicated in this case.
Right.
That would be what I think.
Right, and then there's another question. What if you have to get a J-1 waiver before you do the H-1 case? There's a case that came out in October of 2011 in Tennessee, a district court case where the district court held that all of the legal fees and costs associated with the J-1 waiver we're also the employer's fee because you don't need to incur those costs but for the fact that you're going to get the H-1 status and the H-1 petition next. So that decision only has applicability in that district, which I believe is the Eastern District of Tennessee, but it does show that there's a lot of uncertainty in this area.
Yeah, that's one that I would think is, you would have a very strong case in most courts to
right.
argue that this is not part of the H-1B realm of Department of Labor, but as this case indicates, there's risk all around the edges here. So so as you can tell, this is significant for any employer that's hiring foreign workers. On top of that, the Department of Labor has been increasing the number of audits they're doing of companies, so that the fact that your client may not have had one of these for the last 20 years doesn't mean one isn't just around the corner, because the number that they're doing is growing, and as the job situation is severe, there's even more focus by the Department of Labor on trying to protect U.S. workers. So there's more political pressure to do even more of these. The way this starts is the Wage and Hour Division of the Department of Labor, which is entrusted with enforcing this statute as well as several others, including overtime violations and minimum wages, and is a very formidable, well-organized and highly competent branch of the government. Comes in and tells you what they want to see of the employer's records relating to their H-1 applications. And I've got a sample one here that came into my hands recently, and I'll just run through it and give you an idea of what you have to be prepared, or your client has to be prepared to produce in relatively short order. We'll go into the details of what the regulations say about when these things have to be created. As a practical matter, the Department of Labor will give you some time to get this together normally. But this letter says you're a lucky selectee for our audit, and you don't know whether this is a random thing, but most of them are generated by some complaint. Some U.S. worker who thinks you shouldn't be employing foreign workers, or some foreign worker that you alienated in some way, who thinks that you didn't treat them the way they should have been, can go to the Department of Labor, and you can end up with this full-blown investigation, not just of that one particular H-1, but of everyone you filed during the time period that they questioned. This one was more limited than some could be. In this one, they asked for the payroll records for all current and former employees during a one-year time period. All the time records related to those employees during that time period. Then they wanted a copy of all the labor condition applications that had been filed for foreign workers. This is, as most of you know, the first prerequisite to actually applying for the H-1 is you must get an LCA, labor condition application, approved before you can submit the actual petition. They also ask for documentation of the wage rate that was going to be paid to each of your foreign H-1B workers, a full, clear explanation of the system that was used by the company to set the actual wage paid for all occupations in which you had H-1B workers employed during this time period, and documentation to show how you determined what the prevailing wage was for those occupations for each of those H-1 workers, proof that you provided the required notification of the filing of the LCA. We'll go into that in some more detail later. They asked for the names, job titles, and contact information, address, phone numbers, email of all H-1B employees that you had employed during this time period. And they also asked for names, job titles, phone numbers, and addresses of all U.S. workers that were employed in the same job categories. And then summary of your benefits offered to U.S. workers in the same occupations as H-1B workers. Evidence that the LCA was posted and where and when it was posted. And then they asked for your public access file, which we're going to go into in some detail because that is probably the most complex thing an employer has to go through to comply with these regulations.
Yeah, and if I could jump in there, Bob, the Wage and Hour Division, when it conducts its investigation, is looking at whether you complied with all of these Byzantine requirements in the LCA regulations. And of course, you have to have all the actual wage memoranda. You have to talk about you know, the required wage, the prevailing wage. But the real concern, and you can see that this is true in the school district case, is the H-1 worker being paid what he or she should be paid? And anything, you know, the real penalties, the real liability comes from paying too little, either in comparison with your U.S. workers or in comparison with the prevailing wage. So they're going to look at your what prevailing wage you used. Very few people use the OES wages these days because it's taking so long. So they're using, well, they might use the OES wage, but they're not getting a prevailing wage determination before filing the H-1 petition. So are you using OES? Are you using Radford? Are you using Watson Wyatt? What's your wage source? And is that a proper prevailing wage? I think good faith is a big part of this also. I think employers that are trying to comply, that might have missed a level on OES, it should have been level 2 instead of 3, might have to pay back wages, might have to pay a penalty, but they're not going to be debarred, so they're out of business, or at least out of the business of hiring H-1 employees. So that's the key thing to impress on clients is you have to pay a certain amount, and you can't use the H-1B process for getting around your obligations to pay the required wage.
Very good point, Jim. And it's true that the Department of Labor's major focus is on protecting U.S. workers' wages and working conditions. So the more serious violations of underpaying or violating some of the other representations that relate to that are the ones that they're going to nail the employer most severely for. On the other hand, these guys, to some extent, are bureaucrats who will focus on the nitty-gritty details, so that sometimes an employer can get into pretty serious trouble with what I would consider to be fairly technical violations of not posting notice in the right place or at the right time. That if the particular wage and hour investigator decides that's a substantial violation, carries some fairly serious consequences we'll go into, including a $1,000 fine for each one of those, and being barred, if it's substantial, from filing any petitions for 1 year. So, but it's a good point that trying to comply in good faith really is the most important thing, even if the employer is unable to meet all of the Byzantine, complex, somewhat irrational specifics in the regulations. But we're going to